It is April 17th of 2026, and this is the Court Gallery. Today we're kicking things off with a tense legal showdown over a county zoning permit with a confused Judge Ricke presiding. Then we have a fierce dog park dispute featuring clashing witnesses in Thurston County. Next, we'll see a dad trying to use horrible excuses to dodge jail time for child support, and Judge Mogen is having none of it. Finally, we check in with a defendant with a heartbreaking excuse for skipping a court date, but not all five of them. Judge Lee remains skeptical, and so do I, ladies and gentlemen. Grab your snacks and buckle up. We've got some interesting cases from today's dockets, and it all starts right now.
Plaintiffs versus Board of County Commissioners in Butler County, Kansas. Defendant, case number 2025 CV 259. For purposes of the record, starting with plaintiff, would counsel announce appearances for the record, please?
Patrick Hughes and Robert Kaplan for the plaintiffs, Michael Page and Paula Page.
And Terrence Hulskamp, attorney for Butler County Board of County Commissioners. I'm the Butler County Counselor.
And with you today in your office, if you'd go ahead and make a formal announcement, Mr. Hulskamp.
Yes, sitting in the conference room with me is Toby Stewart, the Director of Community Development, and Tia Ton, who is in the same department.
Very well, thank you. This matter comes before the court at this time for hearing in regards to a motion for summary judgment that was filed by the plaintiffs in this case. I am aware of the county commissioner's response filed through Mr. Hulskamp. Mr. Hughes, you may proceed further in regards to your motion.
May it please the court, this case presents a threshold problem. The board denied the conditional use permit application, but never adopted a rationale that allows the court to review the decision under Kansas law. The question here is not whether there were concerns in the record. There were. The question is whether the board as a governing body identified and adopted a basis for its decision so that this court can review and evaluate whether the decision was lawful and reasonable. That did not occur. The county points to a staff report, public testimony, and statements of individual county commissioners. Those materials are part of the record, but they are not the decision. The record contains no adopted findings, no motion stating reasons, no staff recommendation of denial stating reasons that was followed, no articulated basis of the recommendation of the Planning Commission that was provided to and followed by the County Commission, and no indication of a majority adopted rationale. The court is left with multiple possible explanations, but no indication of which one the board actually adopted. And the local regulations reinforce the problem. Section 22104 requires that the Planning Commission submit a recommendation with the reasons therefore to the board as a precondition to the board having the power to act. What it says is when the Planning Commission submits a recommendation of approval or disapproval of such amendment, revision, change, or conditional use permit, and the reasons therefore, the county board may, and then it gives the power to the county board. Now, the county didn't necessarily have to enact that local law, but it did. And having enacted that local law, it is bound to follow it. It has made its jurisdiction, the board's jurisdiction, dependent on having a recommendation and the reasons therefore, which was not provided. What the record shows instead is a vote to deny, a refusal to reconsider, and individual comments that were never adopted as findings. As a result, the board never received a recommendation accompanied by the reasons as required by the regulation. The county argues that the record as a whole is sufficient because it contains a discussion of traffic and noise and compatibility. But those concerns appear in different parts of the record from different speakers without any determination of either credibility or weight. The board never identified which concerns it adopted, which it rejected, which actually drove the decision. It leaves the court to infer a rationale rather than review one. The county also relies on a declaration from a single commissioner to supply missing rationale, but that declaration was created only after the decision, reflects only one vote, and doesn't show its adoption by the board as a whole. And even taken at face value, it lists multiple factors without identifying which were decisive. That doesn't resolve the absence of a governing body rationale. It confirms it. The declaration also highlights a second issue. It relies in part on alleged zoning violations, such as the mailbox issue and alleged business activity. A conditional use proceeding is not an enforcement action. It doesn't include procedures that an enforcement action does to protect the accused. Even if past zoning compliance might be relevant in limited forward-looking circumstances in some cases, it can't serve as a substitute for enforcement procedures or an independent basis for denial, particularly where the alleged violations were never adjudicated. At a minimum, that reinforces that the decision was based on considerations outside the structured land use analysis that's outlined in Article 22. The county relies on the ultimate standard of review in this case, which is this fairly debatable standard. But that standard applies only after the court can determine what the decision was based on. Here, the threshold problem is the court can't identify a basis adopted by the board, and without that, there's nothing to which the court can defer other than a blanket result. And that is not the nature of the review. We're not reviewing the result, we're reviewing the reasonableness of the decision. In closing, Your Honor, the primary and foundational problem here is not a lack of evidence, it's the absence of a decision that can be reviewed. The board denied the application, but didn't adopt a rationale, and the record doesn't otherwise disclose one. Under Kansas law, this prevents the court from affirming the decision. And even if the court were to look past that threshold defect, the result doesn't change. The Planning Commission didn't comply with its own rules, the own requirements, that did not submit the reasons for its decision. And it's not identifiable from the record. And therefore, what we're left with is a lawfulness problem as well. This isn't a case where the court can defer to a decision. It's a case where the court would have to supply one. And Kansas law doesn't allow that. For those reasons, we ask the court grant summary judgment in favor of the plaintiffs.
And what relief would you seek if this court granted summary judgment, Mr. Hughes?
I think it reverses the decision. The court has two choices. It can reverse the decision, or it can remand the decision for an articulation of the findings for its basis. I think given the problem here, the legality problem, though, is only solved by a reversal. It's not solved by sending it back to the Board of County Commissioners, because the Board of County Commissioners didn't have that prerequisite of having the reasons therefore from the Planning Commission.
Noted, Mr. Hughes. Mr. Huelskamp, you obviously take some opposition to the position taken by the plaintiffs in this case, and at least in one of your pleadings asserted that there was an adequate record made. But I just want to let you know that I have the commission minutes before me, and I don't really see any analysis of factors. So where is this record that you claim exists?
Your Honor, for purposes of a trial, an entire transcript of all the public hearings and all of the meetings before the Board of County Commissioners would be part of the trial transcript. In other words, it would have everything in there that was discussed by the commissioners, all of the public comments that were made, and the analysis and deliberation of the county commissioners in coming to their decision. So that's why part of the affidavit that was submitted was their discussions as part of the transcript of what was said. So the analysis would also be included in any trial transcript. I believe for summary judgment purposes, there's sufficient evidence of what the county commissioners did to justify that what they did was reasonable under the circumstances created by the plaintiff. So that's the analysis we would go through in making that determination.
I'll just note the reference that was made to the Golden decision, where I think it was said that a court must not be left in a quandary as to how the commissioners reached their decision. The fact that they discussed factors as a group in and of itself wouldn't be findings, would it?
No, but they're not required to have findings, Your Honor. There's the law.
So they're not required to analyze each of the factors that their own zoning code says they have to consider?
And they did analyze them during the discussion and deliberation. But the court does not require, the Supreme Court does not require that you have actual findings of fact in making that determination or the motion for denial or approval.
Okay, and what are you relying upon as authority for that proposition?
Cases, Landau, Manley, and in some respects, the Austin case, Your Honor. I mean, the county commissioners did not act in a vacuum. They had staff reports before them. They had 2 planning commission hearings. They had a remand for reconsideration. They had public comments. And during their discussions and deliberations, they identified traffic as an issue, noise as an issue, proximity to existing residents as an issue, safety, and code compliance. And I know the plaintiff's making a big deal about this code compliance, but when it really comes down to it, that's allowing the county commissioners to make a determination as to the credibility of the individuals that came before them as their testimony. So the code compliance, and I think I cited the Taco Bell case in my response, the Taco Bell case said you can take into consideration their credibility once they're not complying with previous codes. So that's why the issue with respect to the mailbox became an issue for Commissioner Herzit. I believe Commissioner Wajak also had a comment with respect to that. So they were weighing the credibility of the applicants with respect to trying to get the CUP for their property because they had already built the event center before they even asked for permission to have a CUP to hold events on the property. So that goes to the credibility of the witnesses. Under Kansas law, there's more than enough to defeat the summary judgment and preserve the board's presumption of reasonableness. And I just don't see how the decision wasn't lawful. I don't see how they can say it was unreasonable. And it was supported by the evidence that was presented at the hearings. And with respect to their argument on the Article 22, our response to the motion for summary judgment on page 7 clearly states, and I hate to read it, but plaintiff also overread Article 22. Section 22-108, the rezoning section, expressly states that the Planning Commission's recommendation shall contain a summary of the facts and a statement of the factors on which the recommendation is based. The conditional use section does not impose the same drafting command. Instead, the conditional use factors section provides that the Planning Commission may recommend approval and the county board may approve a conditional use, the listed factors as guidelines. So during their deliberations, they're using those golden factors as guidelines. Even assuming that section 22-104 requires a recommendation to be accompanied by reasons, those reasons may be reflected in the minutes and incorporated in the record. Nothing in Article 22 required a separate formal findings instrument as a condition of validity for a conditional use permit denial. So they weren't required to have, according to our regulations, the Planning Commission was not required to submit findings to the Board of County Commissioners.
Mr. Hughes, do you disagree with that analysis of the Planning Commission's responsibilities?
I do. I disagree with the analysis. I disagree with several things. First of all, on that question of what is the Planning Commission's responsibility, the 22-104 is the language we're interested in here. And it is unambiguous that it is referring to conditional use permits, not merely zoning changes. When it says that when the Planning Commission submits a recommendation for disapproval of conditional use permit and the reasons therefore, the county board may. Because it's clear, there's no other way to read that than to say that the preconditions to the county board's decision, making some decision, is that there has to be a recommendation that's submitted and the reasons therefore. It's also, Your Honor, with respect to whether we need to have formal findings, I think I don't want to be splitting hairs here. The court said, the Supreme Court has said that the court needs to be not left in a quandary. But that being the case, it is not strictly required that the way that that lack of quandary is resolved is by formal findings. So in the Landau case, for example, the court says, well, what happened here is you had a planning commission report. I'm sorry, a staff report that analyzed all of the factors, recommended the exact thing that the ultimate decision maker did, and they did what was recommended through that analysis that was set out in the staff report. And the court said, well, that's okay. You're not left in a quandary when you have this other mechanism of figuring out what the basis for the decision was. Here, what we have is discussion, a bunch of talk, but we don't know what was important about that talk. We don't know what was believed or what was disbelieved. Can we challenge the reasonableness of a decision if it's based on a factor that was simply wrong? Factually, I think we can, but we don't know that until we know what it is that mattered to the decision. Now, there's this argument that's been made that somehow the credibility of the applicants matter. Well, it might matter if the basis for the decision is a fact on which they testified that nobody else testified, and therefore we care about whether they're credible or not. But we don't know that in the absence of what the factors, what it was that drove the decision. The question of whether they are credible people generally isn't a land use factor. We're trying to determine whether this is compatible with the area, and that has no bearing. And it certainly shouldn't be determined based on somebody's allegation of a violation that has never been adjudicated. And not only has it not been adjudicated, I guess I should add that the county has never actually brought any enforcement action. They've never formally claimed that there was a violation that made him respond to that. They just bring it up now when he makes a conditional use application. If they wanted to have that determination, they should have brought an enforcement action where he can be represented by counsel and we can deal with the question of whether there's a violation or not. They didn't do that. And it's clear particularly from the portion of the transcript that's been transcribed, that it wasn't only one commissioner for whom that became something that was important at one point, at least, in their thinking. And so we can't really tell. Is the decision then based on this inappropriate consideration? The fact is that we'll have a transcript. But it's also true that that transcript is only going to tell us what evidence there was, not how it was thought about, and that this is a summary judgment motion. And if there is something in that transcript that would answer the question of why are we not in a quandary, then it was the obligation of the non-moving party to bring that forward here.
Mr. Hillscamp?
Your Honor, the transcript is not for purposes of the summary judgment. The transcript would be purposes of a trial. It would delineate and allow people to testify with respect to what they said at the public comment sections and at these hearings and at these meetings. They would clearly show that the county commissioners were considering all of the golden factors. They discussed them. They said what was important to them and why they were deliberating certain issues with respect to like the safety. That came up multiple times. The landowners in close proximity to the facility itself. All those things were discussed And I don't know how we can say that it would just, you can submit a motion for summary judgment based upon just a minutes of a meeting. The minutes of the meeting are not the entire meeting and don't have it all in context. Therefore, until you have that transcript and put it into evidence, there is no way that it can be considered unreasonable.
Okay, so Mr. Hillscamp, are you telling this court that if this court were to review this transcript record, each one of these factors would be analyzed by the majority that made the decision on the commission, and that I would be able to tell that they considered the factors that they're required to consider?
The staffing report was reviewed by all of the planning commission members and all of the board of county commissioner members, and they delineated the ones that were important to them, that they thought were factors that needed to be reviewed and discussed and deliberated upon.
All right, so you're telling me that that record would reflect that each one of these three that voted against this conditional use permit approval gave specific reasons during the discussion based on county code factors as to why they were going to vote the way they did?
Your Honor, asking me to, as I remember, each one of the county commissioners had some type of concern that they expressed during their deliberations with respect to golden factors. Now, I'm not saying that all of the commissioners discussed all of the factors, but they did discuss the ones that they felt were important with respect to this application.
Counsel, I recently decided a child custody case. That's not the issue we have before this court, but I'll just note that there are 18 statutory factors for the court to consider in making a custody determination. And I do recall at the conclusion of the trial, this court essentially covered each one of those 18 factors, making some sort of ruling and or finding regarding each one of those factors and how it applied based on the evidence presented. It seems that the bar seems to be much, much lower for a county commission and much, much lower for a planning commission. And I'll make the comment about the planning commission at this time that under 22104, if the county board returns the planning commission's recommendation, the planning commission, after considering the same, may submit its original recommendation, giving the reasons therefore, or submit a new and amended recommendation, which obviously didn't happen here. So did the planning commission, once it was returned to them, give the reasons for their decision, as they are required to do?
On the remand for reconsideration, Your
Yes.
Honor?
Yes.
Yes, they specifically stated in their reconsideration that nothing had changed from the original hearing to make their decision different from what it was initially. That was their consideration.
Okay. So the
there
planning
was
commission
nothing-
made some sort of detailed findings the first time around. Is that what you're saying?
No, they didn't make detailed findings. But they reconsidered it and said nothing had changed from our previous with respect to the property itself. You couldn't change the proximity to the residences. Therefore, how can you make that determination and make a change based upon that remand?
We have a motion, we have a second, and we have a vote. That's what we have. That's what we know. And we have that from the minutes. That's what we know about the decision. Other than that, we know things that were talked about, but not what was believed, not what was the basis of any decision, whether it was the original one or the after remand. When you say nothing's changed, we don't know what that nothing is. What changed from what? We don't know.
Judge Bob Kaplan, you cannot determine reasonability if you're not given reasons. It's that simple. You have to have the reasons for the county commission decision to determine whether or not they're reasonable. What are you gonna base a reasonability determination on? You have no reasons. It's simple.
Mr. Kaplan, Commissioner Herzit stated his decision was influenced by the neighbor's comments and concerns, does not believe the property is a good location for such a venue, and is concerned about compliance to codes. The commission's minutes reflect Commissioner Herzit's statement of reasons. Does it not?
The affidavit filed after the fact reflects his statement of reasons. I think that's what we have is a declaration in support here. He talked about he made comments on items, but again, in connection with the vote, there was nobody said, I'm voting for this because of this or that. And so we have, as for Commissioner Herzit, an after the fact declaration of what the factors were in a vague sense.
Well, I was reading directly from the minutes of the meeting, and I was just, that's the only reflection in the minutes as to what the reasons were, and that was only by a single commissioner. With all due respect to Commissioner Herzit, he does not represent a majority of the board. Those are only some personal comments, and plus I'm somewhat at a loss to even try to determine each one of these three things that he stated, which code factor these would even relate to. All right, what the court needs to determine today is that whether there's a legitimate factual dispute to defeat a ruling on summary judgment in the case. There doesn't seem to be a whole lot of dispute about what really has happened. Somewhat, the record speaks for itself, or the lack of a record speaks for itself. Mr. Hulskamp, I think that you had expressed in your motion that the case isn't ripe for summary judgment because there's legitimate factual disputes. So let's please identify, if you still believe that, what those legitimate factual disputes would be.
Well, first of all, Your Honor, I believe the plaintiffs are just stating that there had to be a finding of facts in the actual motion to make it lawful and reasonable, and that's just not the case. Everything up to the point in which they actually did the motion was lawful, and the decision was reasonable based upon those facts that were presented. In other words, you had public comment with respect to the property being too close to the adjacent landowners. You had safety issues with respect to fire regulations that were not in compliance with our, apparently the fire code, which we don't enforce, but the fire commission does. There were some issues with respect to the noise on the property by the events, because they had some events prior to even submitting an application for a conditional use permit, and the adjacent landowners stated that they had problems because there was too much noise outside the event center. So those are all facts that need to be determined, and whether or not the commissioners actually made a finding of fact, I think what can happen is the commissioners can show that each one of the factors were either determined to be something that they would deny based upon those factors, those golden factors. And given the opportunity, I guess, if they need to have a finding of fact, they can do that. I think that it was done kind of informally, and I understand that it would make it easier for the court if in fact there was a specific finding on everyone, but it's not required by law. So I believe what we need is just something where, if it needs to be remanded back down for them to make a determination for this court's convenience and allowing the court to make a better decision with respect to each one of the golden factors, that can be done. And I think that my response clearly set forth the ones that we were controverting, the factual statements made by the plaintiffs. And I believe also in my response, I listed quite a few additional facts that I think the court needed to take into consideration with respect to just a summary judgment motion at this point in time.
Truly material facts, Mr. Hulskamp?
Your Honor, I didn't understand what you just said.
Oh, I just said, are these truly material facts that you've raised as additional facts for this court to consider?
I believe they are, Your Honor.
Your Honor, we don't contest that there was testimony that the fire official was uncertain about whether or not there was compliance. We don't contest that people had noise concerns that they articulated. Those are not contested facts. The question is not, were there concerns articulated? The question is there a material fact dispute about whether there is an adequate basis to know what the ultimate decision maker found to be the reasons for its decision, and whether the planning commission satisfied the precondition to the board even making its decision by providing a set of its reasons. We have those facts. We have the minutes that show what the motions were. We know those things, and we know that and we have the admission that there isn't something besides that other than looking back at what they could have been looking at, and opinions that they expressed individually at one point in the proceeding.
The moment I'm trying to determine exactly what the planning commission did the first time that they dealt with this issue. I do know that they had submitted to them some rather detailed staff notes or recommendations or suggested findings, depending on how you look at that submission.
There was a staff report that they had that recommended approval. And that is, I think it might be exhibit 1 of, let me look, it's at the bottom of exhibit 1, which is the agenda for that July 1st meeting. At the back of that, there is the staff report, which recommends the approval. And then the court has in exhibit 2, the minutes of that first planning commission. And so there it has we have the motions and second, and the record that they created of what had happened during that proceeding. That would be on page 8, I believe, is where that begins in exhibit 2, and it goes for I think to page 10. So 8, 9, and 10. For what it's worth, at the top of page 8, we do see that the minutes for the previous matter had noted that when the commissioner made the motion, he made the motion with the reason. He referred to reasons on the previous one, which is not the case here.
I see that. And I'll just note that their minutes didn't, as I think Mr. Hughes just suggested, doesn't suggest any reason. Just made a motion to deny 5-0. Okay, so Mr. Huelskamp, as I understand it, your position is that this court, in trying to conduct a judicial review of the commission's decision, which would need to be, this court would need to determine whether it was in the realm of reasonableness, is not supposed to just look at the written record that they created, but try to go back and discern if there was any discussion or any evidence in the record that they might have relied upon in reaching their 3-2 decision to deny. Is that right?
Yes, Your Honor.
Well, frankly, this court disagrees. This court is in a quandary as to how they reached their decision. 3 commissioners agreed to vote down this proposal for a conditional use permit in this case. 2 disagreed. It's not clear what the 3 majority members of the commission relied upon in making their collective decision to deny this conditional use permit. They made no findings. They declared no reasons except for Commissioner Herzet's apparently offhand comments as to what he personally relied upon, which, again, this court sees may not even been pertinent to any of the code factors that they were to consider as a group. And therefore, this court does not have an adequate record before it to make a determination regarding reasonableness of the decision. This court will decline, however, to reverse the decision and order that they approve the conditional use permit, which I think has at least been suggested here. Rather, this court's going to remand this matter back to the Board of County Commissioners of Butler County for what apparently is going to be just a majority of commissioners to make appropriate findings and make an appropriate record regarding their consideration of the factors, which I believe there's 12 individual factors that they are to consider, and what factors they relied upon to reach their decision to deny the conditional use permit. This court will not close this case. The court will leave this civil case open at this current time with this order to remand. Mr. Hughes, I'm going to task you to draft it.
Thank you, Your Honor. It seems to be implicit in the court's ruling, but I want to make sure that the court intends this, that this does not go back, that there isn't a problem with respect to what the Planning Commission provided to the County Commission, such that we need to go back to the Planning Commission to provide their reasons. Because my argument had been that under the regulation, the Planning Commission needs to provide their reasons in order for the County Commission to even have jurisdiction. And I think implicit in the court's ruling is to rule against that argument. Is that correct?
That's correct, Mr. Hughes. Ultimately, it is the position of the commission in this case which this court is to review. While the court is distressed that the Planning Commission did not take their role seriously upon reconsideration, simply stating that their reason is nothing has changed, the court does not see that that is an inherent defect in the proceedings. So the court will rule against that part of your claim, Mr. Hughes. Now, the commission certainly has the latitude upon remand to send it back to the Planning Commission and ask them to take further action in regards to what their rule might be. But I think that's a decision I will leave to the commission rather than to be an order issued by this court. All right. Mr. Hughes, do you need any further clarification regarding the court's ruling here today?
I do not.
Mr. Huelskamp, do you?
No, Your Honor.
All right, thank you both for the quality of your submissions and your arguments. If there's nothing further then at this time, the Page and Board of County Commissioners matters will be in recess, and this meeting may be ended for all at this time. Have a good day, folks.
Cause number 39395, Christine Gertis versus Craft Work K9.
Yes, Your Honor.
Okay, let me see. Close your file. All right, and Wayne, Curry, and Christine. Okay, can you both raise your right hand? Do you swear or affirm any testimony you give will be the truth and nothing but the truth?
Yes.
Yes.
Okay. All right. So I understand this is related to a canine that died. Can you please, Miss, is it Gertis?
Yes, Your Honor.
Okay. Can you please let me know what you're seeking from the court?
I am seeking reimbursement of the fees paid for Isla, which total $9,205.50. I'm seeking the full $10,000. I've had vet bills, medicines, and different aids for the dog that I've purchased that have exceeded that, but I'm seeking the full $10,000 reimbursement for the dog.
Okay, and did you, I don't see anything in the court file. Do you have any evidence of what you've incurred?
I do, Your Honor, yes.
And have you haven't submitted anything to the court?
No, Your Honor, I may need to ask for a continuance on that.
Okay. All right. So, and when was this filed originally? Let me see. This was filed in.
No.
In December 20. Okay. All right. And Mr. Curry, do you have anything to respond? She's going to ask the court for a continuance to provide evidence of her case. Do you have any comments?
That would be fine with me.
Okay, all right, so we'll set it over.
Yeah, our next date is June 26th.
Okay, June 26th, does that work for the parties?
Moment. Yes, Your Honor.
Okay, so we'll get that set over to June 26th. You'll need to file the documents with the court and make sure that Mr. Curry has access to them as well. Okay?
Yes, Your Honor. Thank you.
Okay.
Thank you.
And you guys can sign off now.
Thank you.
And the last matter we have is cause number 39480. And that is Mateo Suarez versus Zoe Petrovic. All right, will you both raise your right hand? Do you swear or affirm any testimony you'll give us the truth and nothing but the truth?
Yes, Your Honor.
Yes, I do.
Okay. All right, Mr. Suarez, this is your claim. I understand it was a dog attack.
Yes, Your Honor.
Okay, can you please tell the court your story of what occurred?
Yes, Your Honor. So we had taken, myself and my wife had taken our dogs to a local dog park where essentially we had been there for about an hour before Miss Petrovic showed up with her dog and her family. Our dog was playing perfectly fine with all the other dogs around. When her dog showed up, mine kind of went over to the fence. He is a little assertive with other dogs, but no harm was caused. He was just being, I guess, a little rowdy. But again, no harm was caused to her dog at all whatsoever. I pulled my dog away, and as time went on, my dog reapproached in a friendly manner at that point. And that is when her dog attacked mine for no reason at all whatsoever. He Hair dog bit my dog's ear and ripped it open. And while that was happening, I believe Miss Petrovic's sister held their dog down. And as soon as she brought the dog to the ground, that is when my dog's ear was ripped open. And so I'm seeking for compensation for the veterinary expenses that we incurred.
Okay. And I see, do you have a witness here that you were wanting to also testify?
I do, Your Honor. That would be Ms. Beatrice Santos. She was also at the dog park and watched the whole thing go down.
And I see another person by the name of Sophia Fitzgerald.
Yes, Your Honor, that would be my wife.
Okay, is she going to testify as well?
Yes, Your Honor, they can both testify to the same occurrence.
Beatrice and Sophia, can I have you both turn your microphones on?
Yes, Your
Can
Honor.
you raise your right hand, both of you? Do you swear or affirm any testimony you give will be the truth and nothing but the truth?
Yes, Your Honor. Yes, Your
Okay.
Honor.
Okay, and Mr. Suarez, it's up to you who goes first, and you can ask questions of them if you like, or you can just let them give their testimony and I may ask a few questions.
Yes, Your Honor. I would like my wife to go first.
Good morning, Your Honor.
Morning.
So, what happened that day, just like my husband said, at the moment of the incident, he was with Rocco, one of our dogs, and I was a little bit more forward in like a bench talking to Via because I met her that day. And when I realized that there was an altercation, I approached the situation when I saw my dog bleeding through his right ear. Mrs. Petrovic approached me. She said that it was the first time that she was taking her dog to a dog park, that her dog was 4 months old, and that she was deeply sorry for what happened. She asked if my dog was okay. I asked her, like, I don't know, but it seems like he's bleeding a lot. I think I'm gonna have to take him to the vet. So I asked her, it's like, it's okay if you give me your phone number and whatever the vet says, I communicate it to you. She says, yes, she provided me her phone number. I called her right there and there just to check that it was her actual phone number. And I told her verbally again, we're going to take him to the vet, and whatever the vet says and how much it is, I'm going to text you and let you know. We left the dog park. We have to put like a Band-Aid around like Rocco's head. I still have the pictures and everything. I texted her, letting her know that we were going to take him, because we called our vet in DuPont, and they told us that since it was an emergency, and apparently not, like it was very possible that my dog was going to need stitches, we needed to take him to the vet, like to an urgent, like an emergency room for animals, like a vet. So I let her know that we were going to take him to, I think it's Blue Pearl Veterinary Emergency Clinic. I think that's the name. I let her know that just for seeing the dog, they were gonna charge us, I think it was like 200 and something. I have it on the chats because I think my husband sent the screenshots as like evidence. I sent her more pictures of how Rocco ear was doing. I tell her that he was bleeding a lot and that I was gonna let her know how much the total was gonna be at the end of everything. She replied that she was sorry again, but she was not gonna be responsible because apparently it was my dog that attacked hers first, which that was not the case. Like my husband said, my dog had been playing, I would say like an hour at that point with other dogs, with like 4 or 5 dogs at the same time. And he has never had an issue. So much so that the other dog that we have is a Chihuahua, and she's the one that rules the house, not even Rocco. So I text her, I was like, okay, if it's your dog that got like affected or like got injured, send me pictures of what my dog caused. She never sent anything. And I told her like, okay, then I'm going to see you in court for small claims. And she was like, okay, so whatever you need to tell me, just send them through a lawyer. And all the screenshots are there. And after that, she never replied. And she kept insisting that it was my dog attacking hers when that was not the case. And I kept asking for like evidence, because if Rocco did some harm, send me pictures so I can be responsible of my dog's actions. She never said like send absolutely anything. And after that, there had not been forth communication. When we tried to serve her, we had to go, I think it was 3 or 4 times, because she refuses to take all the paperwork. We have all those videos. And at the end, we have to leave the documentation with her boyfriend, Dominic Rodriguez. I think it's Dominic, yes. And yeah, so that was it.
Okay.
Thank you.
And then Beatrice.
Yes, Your Honor.
Were you a witness?
Yes.
Okay, can you tell me what you saw?
Yes. So I was at the park with my dog, with Nova, and I have been there for a couple hours before everything happened. And then when Sophia and her husband came in, we just start talking at the table because they have some picnic tables at the park. And I was just talking to Sophia, and my dog was playing with their dog, with Rocco. And Rocco seems very friendly, and they keep playing together now these days. Um, and at the time, I saw Rocco playing with 2 black Labradors for a couple minutes, and they were very friendly. And as soon as everything happened, I just saw that her dog, the black dog with the blue eyes, just jump on him and attack him. And that's all I saw. And I saw that Sophia got pretty desperate. She went in to try to separate them. And that's all I saw.
Okay, I'm going to ask a couple of follow-up questions. Did you see Miss Petrovic and her dog when they arrived at the park?
No, because I was talking to Sophia at the time.
Had they arrived after you were talking to Sophia?
Yes, because we've been talking for hours.
Did you ever observe Rocco attack Miss Petrovic's dog?
No, because he was actually playing with 2 other dogs at the time.
And when you say he, are you referring to Rocco?
Yeah, exactly.
Okay. How do you know Mateo and Sophia?
Oh, I met them that day.
Okay. All right. Anything else you wanted to add?
No.
Mateo, did you want to ask Beatrice any questions yourself?
Um, Yeah, at any point did you see Rocco being aggressive towards her dog after the initial, first contact, which by the way, she didn't even see, but at any point was he hostile to your dog or any other dog at the park for the time that we were there, which like mentioned previously, we had been there for a little over an hour at that point.
No. He just got very excited and he runs around with the dogs, but no, he wasn't hostile at all with any other dogs.
Thank you.
Neither with hers.
Okay, now this might be a little uncomfortable, but I have to give Ms. Petrovich the right to ask you, Beatrice, a couple of questions if she would like to do that. Ms. Petrovich, would you like to ask this witness? And we're going to just do Beatrice Santos first. Did you want to ask her any questions?
Yes, actually. So whenever they were leaving, I only saw one dog. They only left with Rocco, and they all three of them left
Okay.
together.
Zoe, I'm sorry, Ms. Petrovich. So right now, I'm going to hear from you in a minute. My question was, do you have a question you would like to ask of Ms. Santos while she's testifying?
Sure. What type of dog was your dog? Because I did not see you leave with a dog. I only saw you leave with Mateo and Sophia.
My dog is a half lab, half German Shepherd. She's a female.
Okay.
And she's about 2 years old.
Gotcha. And you had that dog there that day. You did not come with Sophia and Mateo.
No, I was there for a long time before they came. And my dog, we are pretty new here in Washington, so I'm just showing her around. That was like actually a new park for us. We've been there just like a few times, and she was like very close to me. So she would be around me a lot because she was a little bit shy of meeting other dogs.
Okay. So Ms. Petrovich, did you have any other questions for Ms. Santos?
No, I don't think so.
Okay. All right. Ms. Santos, there's no other questions for you right now. If you want to just hang on in case somebody else has other questions, but you can turn off your microphone for now. I want to go back to Ms. Fitzgerald. You need to turn on your microphone for a minute.
Yes, Your Honor.
So, Mr. Suarez, did you want to ask Ms. Fitzgerald any questions beyond what she testified to?
Let me see. During when Rocco approached that second time that he was attacked, do you feel that he was being hostile to either Miss Petrovic, her family, or her dog at any point in time?
Not at all. Especially because at that specific moment, just like Via said, he was playing with two other black labs and they were like running around. And the three of them went towards that direction, but Rocco like kind of went to like smell. I think Miss Petrovic was with a little girl. I don't know, probably it's her daughter. I'm like how you say, like
Assuming.
speculating. Yeah, speculating. And he kind of like smelled her and like mind his business. And when he was about to turn around to keep playing with the other two labs, that's when Miss Petrovic's dog caught him.
Thank you.
Okay. And again, Ms. Petrovich, do you have any questions for this particular witness?
No, I don't think so.
Okay. All right. Okay, Mr. Soros, was there anything else you wanted to present? Otherwise, I'm going to hear from Ms. Petrovich and then we'll come back to you. Okay.
Sounds good, Your Honor. As far as everything, I presented all the evidence to the court. My payments or my payment made to the veterinary clinic. The messages between my wife and Ms. Petrovic should all be there as well, and those should include the pictures of the injury that was caused to my dog.
Okay. And all right. So Ms. Petrovic.
Do I just start and just like explain everything?
Yeah.
Okay. So first thing, whenever we got to the dog park, this was not our first time at the dog park. We've been there many times. We, in fact, just went there yesterday, and my dog did fine playing with all the other dogs. Whenever we first got in the dog park, like as soon as we entered the gate, there's like a little area that's right there, and it just opens up to a really big field. This white dog, Rocco, just ran up and starts like attacking my dog. Not, like he said, his dog is assertive and might play a little more rough. And so that was my first time without my boyfriend going to the dog park. So that's why I felt in such a way. But there was an older gentleman there, and Rocco just kind of kept going at my dog. And the older gentleman offered to give his leash because I was looking around and Rocco had no owner at this point. And I was yelling out. I yelled out at least 4 times. I said, "Whose dog is this? Whose dog is this?" And Rocco's owner was not near him at all. Finally, Rocco's owner, Mateo, comes up like over a hill and then comes down, and I was like, "Is this your dog?" And he's like, "Yeah." And I was like, "Well, he just tried attacking my dog, and I would like it if you could keep eyes on him." And he's like, "Oh, okay. My dog just has to assert his dominance sometimes." Those were his exact words. And I was like, okay, I wasn't sure how to respond to that. Being at an off-leash dog park, no dog should be asserting any type of dominance at an off-leash dog park. And so I said, okay, if you could just keep an eye on him. And then we all walked off. He walked off with his dog, and we walked in the other direction, and they all kept playing. Everything was going fine. Everyone was playing fine. About maybe 30 minutes afterwards, after that altercation, a bunch of dogs, what they're also missing out is they're saying it was just my dog and just Rocco. There was like 4 dogs that were all playing together, and someone, I'm not sure which exact dog, but someone started growling. Maybe one of the dogs got uncomfortable or whatnot, but one of the dogs started growling. And then from my side, I saw Rocco lunge towards my dog. My sister at that point took her body. She is like 5 foot. She took her whole body and threw her body on top of my dog. And at that point, Rocco was still not, he was still attacking. He would not stop. Even with a human fully on top of my dog, he was still attacking. And my sister actually got scrapes on both of her, or one, I think was one of her arms. I submitted pictures. But she got scrapes on her arms from this. Mateo stated that he had to control his dog because I couldn't get a control of my dog. He could not get a control of his dog until my sister was fully on top of my dog, and he was able to actually grab his dog and walk away. He walked over to the side, and I came over, just being a nice person. I came over and said, "Hey, sorry about this. He's just a puppy. I've never had an altercation at a dog park." I offered to give them my phone number. I said, "Let me know how he's doing." I never once stated that I would pay for any veteran bills. I never said anything of that sort, to be honest. I didn't say any of that. I stated I gave them my phone number just out of being a nice person. And so that way I knew that their dog was also okay. After that, we stayed there. They left. We stayed. My dog can continue playing just fine. We left about a half hour after that. And then I came home and actually called the police, and I made a police report. In the police report, I have it here, but it just states that I just wanted to document it. It says, "I am aware that the other party could take me to small claims court. The police advised me to document everything and take photos." That's why I took photos of my sister's arms. I also submitted every single text message. They said they submitted all of the text messages, which they did not, because I submitted all of them, every single one. I asked Sophia not to text me anymore. I said, "Any communication you do, I want you to do through a lawyer." And she responded with, "Girl, if you can't afford a lawyer, or if you can't afford a vet bill, you can't afford a lawyer," which she's completely correct. I'm a single mom, and I actually get help from the state just to pay my bills because I can't even pay them. So let me look through. I submitted, like I said, all of the text messages. I submitted the pictures of her arms. I have 41 pages here of my evidence, and they submitted 8 pages of their evidence. But I submitted the police report. I submitted my statement, which was 3 pages long. I kind of just tried to put everything as much into detail as I could. And then my sister's statement and the pictures of my sister's arms. My daughter was also just really scared about what had happened. Again, we've been here many times and we never had any issues. My daughter was like clinging to my leg because of how scared she was that this dog had attacked my dog. Yeah, I think that about covers it. Again,
So let me ask,
sorry.
let me ask you a question. So you submitted some photos that I believe of your sister's arm.
Yes.
How did she get, it looks like either a scratch or something. Where did that come from?
It came from Rocco whenever she threw her body over my dog.
Okay, and was this, well, let me ask, did your dog actually bite Rocco? Because Rocco had a bleeding ear. Was it your dog that bit Rocco?
At that point, yes, it would have been my dog that bit him because it was only those two dogs. Like I said, when they first started like growling and stuff, there was a bunch of them, but the other dogs fled. And at that point, it was just Rocco and Lynx, and things were already going so fast that my sister just threw her body, like tried separating them, and then we couldn't get them separated. There was 3 men just standing around. Mateo was standing there, another guy was standing there, and another guy. And my sister she's tiny, she's like 100 pounds and she's 5 foot. And she like, just they were fighting, so she threw her body on top of my dog, and then Mateo finally got his dog.
And so my question about her scratch that she has on her arm, was that before or after Rocco was bitten?
I am not sure about that because we don't know exactly when Rocco got bit. We just know it happened during that altercation.
Okay. And I know in your materials that you had indicated that Rocco had kind of come around and was roughhousing with other dogs.
Yes, that's what we had seen. I'd love to have my sister here as a witness as well, but she doesn't do good with confrontating with people, so she didn't want to be a part of it. And my daughter, I mean, I would love to have her here, but she's here. She's at school. That would have been a good person to have as my daughter. She's 5 years old and she could say things, but I also didn't want to, put her on the spot like that and make her feel some type of way.
Okay. How long had you been at the dog park when the incident occurred?
The first incident or the second incident?
Well, you tell me what is the first incident? What is the second incident?
The first incident would be whenever we got into the dog park and Rocco came up to my dog and started attacking him the first time.
And by coming up and attacking him, what was he doing?
He tried humping him, and then my dog like ran from him. And so he went after him and was trying to bite him. And that's when the older gentleman was like, "Do you want my leash?" and trying to offer a leash so we could leash Rocco.
Okay. And then how long had you been at the park when that first incident happened?
Like 1 minute. We just entered the dog park. We weren't even away from the gate at that point.
And what about the second incident?
It had been maybe about 30 minutes or so.
All right. Anything else you want to add?
Yes, just again that I did not see Beatrice leave with a dog. Also, Sophia is calling her B or B. For me being like someone who just met someone, I usually don't call them nicknames. I would state their full name. I did not see Beatrice leave with a dog. I just saw her walking off with Sophia and Mateo.
Okay.
Sorry, Your Honor, can I say something?
Well, let me let Ms. Petrovich finish first. Okay. Anything else you want to add?
No, that's it.
Okay. All right. And so Mateo, we're back to you. Sorry, Mr. Suarez. It sounds like one of your witnesses would like to add something. So do you have, would you like?
Sure, Your Honor. Now, mind you, my wife and Miss Santos have become friends since that specific day. We had only met that specific day. And if my wife wants to confirm that as well, or Miss Beatrice as well, they can both confirm the same story.
Okay.
So I did leave a couple minutes after they got out of the gate of the park because I saw the blood and I saw Mateo washing the dog's ears outside in the water. And I was asking them, are your dog okay? Is he gonna be okay? And they say, oh no, we have to get him into the vet because he's bleeding a lot. So that's what happened after the incident happened. And then I went home with my own dog. But I've been to the park for a long time. And after the accident happened, I was like, okay, maybe I just want to leave because it's been a long time here. And it happened this, and I don't want anything else happen to my own dog. So that's why I left almost the same time they left too. And yes, I've never met them before the park. I met them after, during that day, and after we became closer because both of us have dogs. And also, I'm expecting a baby, and she has a baby. So we were talking about maternity, and those stuff made us more connected. So that's all I have to add.
Okay.
What I gotta add, Your Honor, is like just like Beatrice said, because if I say Bea, probably it's not appropriate. That day we met in the park because I was also with my baby. That was on February, if I'm not wrong. I don't
Yes.
remember. Yeah, okay. So my son was 7 months old. I was with my son. And when we saw like at the picnic tables, we start talking because Bia was like playing with my son and talking. There were also another two ladies talking to us. And then we start like bonding for the fact that she told me that she was expecting. And she told me that she was from Brazil. I told her that I was from Colombia. So we start bonding about that. And that's what we were talking the entire time on the picnic tables when Mateo was with Rocco, just like follow him to whatever Rocco was running around. And after that, when I was talking to Bia, we exchanged phone numbers even before the incident, because I explained to her how hard it is to be in a country that is not yours and being pregnant, like all that involves. And I told her like, hey, this is my phone number. If you ever want to text me and you want to go grab a coffee or something, feel free to do so, because I know how hard it is to be alone in a country that is not yours. That's why we start talking after that day.
Okay. Miss Fitzgerald, did you witness the incident where Rocco was bitten?
Yes, Your Honor.
Okay. Was there any period of time when you were in a location where you were not able to see Rocco?
The first, like Ms. Petrovic mentioned, like the first interaction that the two have, I did not see it because he was from the table that I was sitting at is a little far away, and I have like some issues with my side. So I could see like my dog running around, but I didn't see like the first interaction itself. But the second, like the actual incident, the attack, I saw it, and I also saw how Mrs. Petrovic's sister jumped on top of their dog. And I think the jump was the reason why my dog ear got like the tearing. Because when heard, I think that's what happened when the dog bite my dog's ear and she jumped on top of their dog, that made like the bite to be like, how you say it, like longer, bigger. Like it tear the ear off, not off, apart.
Okay. All right. Anything else you want to add, Mr. Suarez?
Yes, Your Honor. So, my wife was in line of sight of, when the whole incident happened. I genuinely believe that Ms. Petrovic's sister's cuts or scrapes on her arm were when she jumped on top of her dog to stop him from biting mine. It wasn't that she was defending her dog. It was that she was stopping her dog from, being aggressive towards mine, which is where she jumped on top of the dog. Her dog already had its mouth clamped around my dog's ear, and that's what caused the tear. But again, my dog didn't cause any harm to either her sister or her dog or anybody else at that dog park at that time.
Okay. Okay. In reviewing the evidence as a whole, I am going to award for the plaintiff on this matter for the vet bill and the filing fee It does appear that injuries sustained by the sister, I can't remember her name, I apologize, were sustained after the fact by injecting herself in between two dogs that were being aggressive with each other. I am signing an order to that effect, and that will be available on the court website later today. So you're all dismissed. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good day.
We will go on the record in the matter 16 FA11, in re the support or maintenance of Dante Chavarria. Appearances are, we do have Corporation Counsel Stephanie Thomas Schmidt in person. We have Mr. Chavarria in person without counsel. We're set today in this matter for a motion hearing. I believe the last time we were here was April 3rd, 2025. So it's been a year. He was held in contempt, put on purge conditions. Mr. Chavarria, you are here. A warrant is issued in this matter. And so we're here today, at least, well, right now the court is going to issue a warrant on January 30th, 2026. What?
I did not know about that until they told me.
Yes, so a warrant has been issued. The warrant is quashed for this hearing. Do you understand that you have the right to an attorney?
I guess so. Yeah.
Yeah.
You know, it's just.
I mean,
Could you speak up and into the microphone a little bit? I'm having a difficult time hearing you.
microphone to you. Thank you.
Yeah, I do know that.
And I mean, you've been here before, and it looks like all the times without counsel.
Yeah, I've never had an attorney. Yes. So.
Yes, and so you represent yourself.
Yeah, I guess
in this
so.
matter.
Yeah.
And so, I mean, you've been here before multiple times, correct?
Yeah, yep.
Okay, and so you understand what's going on in the process?
Yeah.
Okay. So Ms. Thomas Schmidt, I believe that in your warrant, you are asking to lift the stay due to the failure to comply with purge conditions?
That is what we requested and received order in January. Yes, Your Honor. By way of history, Mr. Chavarria was found in contempt April 3rd, given a sentence of 90 days jail. His purge was to make his monthly payments and to seek work 3 applications per week, turn that work search effort into child support. We've received 0 work search applications. At some point last summer, I've got the document with the date in front of me in a moment. We initiated a notice that Mr. Chavarria was delinquent on his purge, and if he didn't comply, we would take further action. That occurred in May of 2025. Following that, we did receive a few payments, which stopped in July of 2025. Mr. Chavarria received notices of delinquency in November. And then we filed the paperwork in January for the warrant and commitment order. The language of the purge allowed for the commitment, the stay on the commitment to be lifted if he doesn't request a hearing. The documents in question that I've all referenced were all sent to Mr. Chavarria's address that he has on file. So he's imputed to have received that correspondence, that communication. And then we received no contact, no payment, no work search, no nothing until Mr. Chavarria was released from custody on a separate matter where he was not taken into custody on this matter for whatever reason. When he was released from custody the other day, he stopped at the child support window, indicated he thought everything was just magically being taken care of, and indicated that he had filed his taxes and there would be a tax intercept. He discussed his mother or other relative, I don't remember exactly who, would be willing to assign her per capita to pay his child support. Frankly, we have no jurisdiction over any individual other than Mr. Chavarria, and it's his responsibility. I am at a loss for why I should not ask for the commitment to be reinstated and for him to go into custody today.
Yes, Mr. Chavarria, you're going to get an opportunity to provide information to me and whatnot.
All
And I am going to ask that you tell me about your work searches and if you have a job and if you have the ability to pay and why you haven't.
All right. Right now?
Yes, in the
Oh,
microphone though.
Okay, yeah, I did come up here the other day and because I know I'm here for not paying child support and stuff, but I ended up getting a letter in the mail saying that they took my taxes. But they put something in, I don't know, January or something that I had to pay like, I don't know, what was it, 200 or something, where I would get locked up for 9 days. But for my taxes, they took 1,700 away. So, you know what I mean? 1,700 went to the child support. I showed one of the child support ladies the letter that I got. And my work history,
Let me first then, was there a tax intercept?
He did show a piece, document from an entity that indicated that there would be a tax intercept. As of yesterday, it has not posted.
All right, so it hasn't posted yet. So until it posts, it doesn't.
yeah, and it came from the IRS too. So, I mean, you know what I mean?
Yeah, but here's the thing.
My bad,
Did
my
it
bad.
say it went to Burnett County Child Support Agency for Dante?
Yeah, it specifically said that on there. Yeah,
All of that?
all of it. Yeah.
Okay.
Yeah, that child support took it away and everything. Yeah.
How much does he owe in past in arrears?
There's the sheet. I had it right in front of me.
Can I say something else?
What, Mr. Ricke?
And I mean, I feel bad that I'm asking my parents for help, but and they said that I could get my mom to sign something for some money to be taken out of her per cap. And I got that piece of paper in my pocket. She signed it, and it says the amount that's going to be taken out and stuff. So
I'm not sure. I mean, I know that there's that signature. Did she file it with the tribe?
oh, it went like this. She talked to them about it, but she never ended up signing it. So the day that I came up here, she gave me the piece of paper to take to my mom and sign, and she signed it, and I have it with me.
So, but that has to be turned into the tribe, correct?
Turns into the child support and then
Yeah,
child
child
support
support.
sends it to the tribe.
Okay, all right, but you have that document?
Yeah, somewhere.
Um,
Yeah, I
And-
got it. Oh man. Yeah.
The delinquency, the debt total is $5,502.87 as of April 13th.
All right, as of April 13th. So
And then
that 1,700 is just a little drop in the bucket.
That 1,700 is approximately, give or take, the amount of the purge, that he was delinquent on the purge. But typically, under most circumstances, an involuntary payment is not considered compliance with every month's order to make a monthly payment.
Okay, so
I mean, they did it for me. I'm not mad at that. So
no,
that's
no,
cool.
they have to. If
The IRS is required to do it.
So if I'm hearing you correctly, you're stating that that was something that was done because that's what the IRS does.
Mhm.
And even though it's 1,700 and it would almost bring the purge to zero,
Yeah.
that is counted not as the purge requirement, but it would be from other money arrears.
In most cases, that's correct. It's not counted as your monthly payment because it's involuntary. It's not something that he affirmatively did. And it's only 1 month worth of payment. After several months of not payment. It's not a case of prepaying ahead. It's a case of being a year behind and then paying at the end.
All right, so let's say that all of this is true before I even get into the work searches. And the child support's going to be receiving around 1,700 and they have the authority to take per capita from Mr. Chevria's mom. Isn't she your stepmom?
Yeah, she's my stepmom.
Stepmom. What would the position of child support be? Or do you want to hear work searches and things first?
I suppose there's an extent to which that doesn't really change my perspective, because even if he did apply for work, even if he was working, he didn't notify child support, which is part of the order. I certainly don't want to discourage compliance, but I am still concerned because we have no authority over Mr. Chevria's stepmother. She can sign the paper and then immediately turn around and revoke that. And to have that be the assurance that child support will be paid is not something we can ensure. Yeah, it's generous of Mr. Chevria's stepmother, but the requirements to meet your payments, to do work search, to keep in contact are things that Mr. Chevria has to do, not other people. So I suppose if Your Honor were feeling generous.
Oh, I'm asking if the child support is, if Corporation Counsel Child Support Agency is feeling generous. Because to me, Mr. Chevria, I'm going to tell you, for the last year, since last April, whatever it was, 2025, I see that you've done nothing that you were supposed to do. So quite honestly, based upon that alone, I can say, too bad, so sad, lifting the stay, go spend the time in jail. Why does it take, why is it always when it's like the person is facing the jail time that they scramble and they figure it out and they try and find ways to bail themselves out of jail when they could have just been complying all along?
I mean, like I told you, I feel bad that my mom's doing it, but I actually thought that this paper was already signed. That's why I wasn't in jail, because I didn't know about the warrant until, they told me, you know what I mean?
So how much is she willing to allow?
It says
per
right
capita?
here, 161 a month.
Is that what it
And
is?
And she's making me feel like the IRS paid her that money. That money. That was my money. You know what I mean? So,
Well, here's the thing,
and
they
I'm
did.
happy they took it. It's all
gonna
right. I'm
tell
cool
you.
with that.
I'm going to tell you,
But she's making it sound like, they paid us.
but they did, because I'm going to tell
But
you,
it's,
my gut tells me that if you would have got that $1,700, you wouldn't have went, hey, I'm going to go and bring that and pay that towards my past child support. I don't think you would. And I like you, Mr. Chevria.
But yeah.
So you wouldn't have, would you? You wouldn't have taken
No,
that
I
check
would've-
and brought
not
it
all
over.
of it, not all. I'm not gonna lie, not all of it. No, but you know what I mean. The months that I was late, that I didn't know that, because she said she had the papers signed or written out and everything, and my mom didn't come up here and sign it. So, you know what I mean. And for me not to know that I had a warrant out for child support, because you guys let me out of jail, you know what I'm talking about? And one of the ladies were like, they weren't supposed to let you out. I was like, why? Like, because you have a warrant out.
Well, they shouldn't have,
But
but
yeah,
that was
and
an
now-
oversight.
And I didn't even know that, you know what I'm talking about? So that whole time, I actually thought it was getting taken care of, and I was working last year.
So is it 161? But then why weren't you paying? You just spilled the beans if you were
I know.
working. Why weren't you paying?
I was giving the money to my mom because I thought she was, you know what I mean? I told my mom, because she was taking care of it, that I would start paying her the stuff that she paid every month. So.
Everybody else's fault, Mr. Chevria.
No, it's not. That's what I'm saying.
Okay, so it's 161 a month.
136 in current support and 25 a month in arrearages. So yes, the 161 total.
Okay. Oh, you tell me, Ms. Thomas. I'm fine if you want to be lenient. I'm fine if you don't, quite honestly.
I gotta really look into that too, because when I was working at North States, they knew, I told them. I'm not too sure if they were taking some out, so
We
I'm pretty
received
sure.
we
They
received
searched
3 months
for
worth.
3 months?
See,
3 months is the
yup,
total
see?
of what we received over
I
the
got paid
past
every
12.
week too, so.
Okay, but you can't talk at the same time.
Oh.
Mhm.
Well, they got 3 months, but that wasn't nearly enough. I just set Mr. Chavaria. Did I just set Mr. Chavaria?
For the 28th, I believe.
Yeah. So would you like to adjourn this to the 28th, Ms. Thomas Schmidt?
Honestly, I feel like we're a day late and $1 short. I am concerned by the reliance on Mr. Chevria's stepmother, particularly given his comments that he thought his stepmother was paying. He was giving the money to stepmother to pay all of the things.
That part yet.
I'm concerned about that being the plan for compliance going forward. I'm concerned about Mr. Chavaria saying he didn't receive any of our communication or correspondence, the warrant and such, when he's required to keep his address up to date with the court and with the child support agency. I've been encouraged to show an attempt to regain compliance. I'm struggling to see how this is any different than anyone else in similar circumstances where I would be asking for a warrant.
Has he had to sit any jail time for failure to comply and pay child support in the past? I'm getting an indication of no.
I'm not.
How many days are you asking?
The order is for 90. I suppose I'd ask for the stay to be lifted on 7 days and the purge to be extended for 1 year, that Mr. Chavaria make his payments. If he doesn't make his payments, to do work searches, and then on top of that, to have monthly communication with child support to verify payments, if the per capita assignment from your stepmother is still active, to verify that remains effective. And if it doesn't remain effective or enough doesn't come in, you've got to figure out what you're going to do about it.
All right, so what I'm hearing, Mr. Chavaria, is that child support is saying, you know what? I'm not going to ask for the 90 days, which, and I'm recalling, and 90 days was a lot since it has been a very long time, and you haven't sat jail yet. They're only asking for 7 days in custody, and that they will ask the court to extend the purge conditions, which would include monthly communications with the child support, picking up the phone and calling and talking to them, or stopping and talking to them, the work searches, and per capita, that remains in effect if or until you have a job that can at least pay your monthly payment with arrears.
I ended up calling Express yesterday, and they're looking to maybe hire or trying to hire me back at North States.
That would be good.
Yeah.
But so, Mr. Chavaria, you have time to make an argument, because I could do the full 90, I could do 7. What's your argument?
I mean, yeah, I really didn't know I had the warrant. I thought it had been, because everybody seemed surprised. I mean, you were probably surprised when they came in to tell you that I had a warrant.
Well,
so I really didn't know, you know what I mean? Like,
tell you, I was, but I wasn't, because I signed the warrant for you, but you were in custody, quite honestly.
oh, so
I
really had no knowledge of it and stuff like that. And it hit me pretty hard. Like, you know, once she told me, after she told me, it seemed like then everybody knew, you know what I mean? So like, then she told me if I signed this, you know what I mean, it would take care of the warrant.
What's the address that you have for him?
4379.
getting the communications because he gets the communications from his his criminal matters.
Yeah.
You're getting the communications from child support, Mr. Chavaria, and don't lie.
Yeah, I get the things that tell me the bill. Sometimes I haven't seen a warrant or anything like that telling me that I had a warrant out and nothing
Well,
like that.
I don't know if we send,
See, yeah,
I don't know if we send notices of warrants.
or I don't know.
I
or
have the
telling me
notice of
that-
motion and motion for warrant and commitment order that was mailed to that address that gives Mr. Chavaria the information about why we're requesting a warrant, what it means, and how to contest it or address it or request a hearing or take any action whatsoever.
But that was prior to me signing the warrant, correct?
Yep, that was sent a few days before you signed the warrant. The notice, or that was sent January 5th-ish, and the warrant was signed January 30th. So even if he didn't have notice that it was signed, he had notice that it would be signed.
I'm just still confused how we're even talking about the word. Like, I really just didn't know. But yeah, I mean, I called and asked Express if they could help me find a job, and then
Well,
I
Mr.
got my mom to
Chavaria,
sign that. So.
I want you to have a job. Child support wants you to have a job. Your child wants you to have a job. I am going to lift the stay on 7 days. And I am going to, I'll extend the purge for another year from April 17 to April 17 or 16. With the further conditions of monthly communications, work searches, and that the per capita signed by your stepmom remains effective and continues to remain effective. And the 7 days gives child support enough time to verify with the tribe that it's going to be in effect. And it gives child support the time to verify if that IRS tax intercept really did occur and will be applied to your arrears. Because if it hasn't, then quite honestly, child support can come back and ask that the court lift the stay for the entire 90 days.
I mean, I don't have that letter on me, but I mean, you know, I mean, my dad can bring it up here some, because it really does say for Burnett County Court, and it says child support, and then it says my son's name on it.
Did you give a copy to child support?
No, I just showed her on my phone because I didn't have that piece of paper,
Nope.
but.
And I think it's wise that your dad brings that up.
All right.
Because
It specifically said for the child support in this building, you know what I mean, that they took it, you know?
but I don't have that to look at.
I know, I'm sorry, my bad.
And Ms. Thomas Schmidt doesn't have it. So the court is going to lift the stay for the 7 days effective immediately. And I guess we will see you on the 28th, which is not too long away.
The monthly contact with child support as well?
Yeah, I ordered all of those.
Okay.
The monthly contact, the work searches, and the per capita must remain in effect. And if it doesn't remain in effect, Ms. Thomas Schmidt, then there is the ability for child support to request an immediate lift of stay.
Okay.
Unless he has another income source that is paying his amount. All right. We are adjourned. Mr. Connors.
Oh, shit. Here, do I just give that to her? Or
Yes. Or it can
just
be-
do the
it can
7 days
stay
and
there.
that's it? Though?
7 days
Alright,
for
yeah.
this. I think you'll still be in custody by the time I see you on the 28th.
All right.
And to be clear, the 7 days isn't, the 7 days is what sits now. The remaining 83 remains over your head as available if you continue not to comply with the purge.
How does that go?
After you sit the 7 days, you have to continue to pay your child support and your arrears. Do what you need to do. And
Okay.
if you don't have a job, then you still need the monthly communication with child support. You need to apply for a work search
All
for
right.
jobs and give it to child support. How many did you ask for? A week, 4?
Usually the order currently says 3. Usually we do 2, so I'll just say 2.
Oh, 2 is good. Just 2 a week. And that the per capita, if you don't have a job or ability to pay yourself, then the per capita authorization from your stepmom must remain current. Otherwise, the stay can be lifted. You can sit the rest of the 83 days. That's what it is. All right, Mr. Connors. She'll go get it when she's leaving. We will go on the record in the matters 25 CM 180, 26 CT 16, State of Wisconsin versus Richard Connors. This date appears through District Attorney Kevin Schmidt in person. We have Mr. Connors appearing in person in custody with counsel Joel Flisky. We're set today in this matter for a plea and sentencing. Mr. Flisky, the parties have reached an agreement. What is the agreement that's been reached?
Thank you, Your Honor. The parties have reached an agreement to resolve these matters for Mr. Connors to plead to the sole count in both 25 CM 180 along with 26 CT 16. We will be making a joint recommendation on 25 CM 180 for Mr. Connors to complete an AODA assessment along with court costs, and for on 26 CT 16 to be sentenced to time served. I have credit here for 17 days from the time of his arrest on March 31st of 2026 until today's date. If I did not already say to the court, there will be court costs on each count. I have a completed plea questionnaire, which I've reviewed with Mr. Connors. May I approach?
You may. For full disclosure, if the court does follow the recommendation and do a time served for the cases, you're still not getting out today, Mr. Connors, because I need to set a hearing on your fines and fees. That $13,000 we were talking about. So do you understand?
We
that?
already did that hearing, and you
No, I
said
didn't.
30 days, I thought it was.
Don't believe I
thought we did it, what was last Tuesday or whatever, and you said anytime I miss a payment, $500 payment, you said you'll throw my butt right in here for 30 days.
Did you make your payment?
No, I haven't been able to, not from in
Well,
here.
yeah, you can't get out until you make that payment. You're not getting out until you make a payment.
Well, it'd be 30 days to sit then, wouldn't it?
No. It was $500 down, if I'm recalling correctly. I don't know, seeing you so much is, I have to bring it up. You didn't bring your stuff. Go way back to whatever cases it was, way back in the day. Did you get an order on that? Because if you didn't get an order on that, then I don't.
No, I didn't get nothing.
Then it
written down.
doesn't exist until there's an order. I will ask Amy.
I think we just did it on the status conference or whatever it was last Monday or Tuesday.
And my recollection is $500 down. Yep. Court will accept $500 down payment for failure to pay, $500 per month, 30 days in jail if you fail to continue each month. So yes, we did already have that. So until you pay $500 down, you will not be released.
So I'm in here until I get $500?
Correct.
How the heck am I supposed to get $500 while I'm in here?
I don't know, you figure it out. And then if you can't, then you write the court and we'll have to have another hearing. All right. Yes, you're correct. We did have that hearing, so we don't have to set it. The court did make an order, and then if you can't come up with $500, then that's where you have to write the court and plead. Otherwise, if you can't make the $500 payment, then honestly, then the stay gets lifted and you have to sit that 30 days.
So 30 days then?
We'll see. All right, so I have the plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Okay. Did your attorney go over that with you?
Yes.
Did he go over it thoroughly with you?
Yes.
And you understand it completely?
Yes.
Okay. Is that your signature on the second page?
Yep.
So you're pleading guilty to both of those counts. You understand everything completely, thoroughly? And if you hadn't, is that a yes?
Yes.
And your attorney, if you had any questions, he fully explained it to you, tell you understood? You're 43, 12 years of schooling. You can read, write, you understand the English language, no drugs, alcohol, medications, mental illnesses or disorders. Did your attorney thoroughly go over your constitutional rights with you?
Yes.
And you understand them completely?
Yes.
And do you need me to go over those rights with you in any more detail?
No.
You understand that by pleading guilty, you're waiving and giving up those rights?
Yep.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand here that the state's going to have to prove on or around, wait, let me get all the other cases that you have gone. State would have to prove on or around April 31st, 2026 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you operated a motor vehicle on a highway or roadway of the state. And that revocation was a result of an OWI or similar related offense. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty is a fine of up to $2,500 or imprisonment of no more than 1 year in the county jail or both?
Yes.
You also understand that with regards to the disorderly conduct, the state would have to prove on or around August 19, 2025, while in a private place in Burnett County, you engaged in unreasonably loud, boisterous, or otherwise disorderly conduct, which tended to provoke a disturbance. The maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both. Do you understand that charge and the maximum penalty?
Yes.
Do you understand that there is an agreement that's been reached between the parties and it was recited on the record, but I am not bound to follow that agreement? Do you understand that?
Yes.
Said differently, I could sentence you to the maximum possible penalty today if I thought it was warranted.
Yes.
Do you still wish to continue and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, did you go over the probable cause section of that criminal complaint?
Yes.
For the most part, it's actually for both of those complaints. For the most part, are those facts accurate in both of those criminal complaints?
Yes, Your Honor.
Mr. Flailing, may the court use the probable cause section of the criminal complaints to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing.
Yes.
And voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions? Right? Has he looked at this matter thoroughly?
Yep.
Has he discussed this with you, of whether or not you have any defenses or a lack of defenses?
Yeah, you discussed it with me.
And you're satisfied with his services?
Yep.
Any questions for the court or for your attorney before I proceed?
No.
As to count 1 in 26 CT 16, operating while revoked, how do you wish to plead?
Guilty.
As in count 1 in 25 CM 180, disorderly conduct, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both of those charges. Judgment of conviction will be entered today. Argument, Mr. Schmidt.
His disposition's appropriate. He's been in custody for a while. The cases are OAR, which he has a significant history of, and the disorderly conduct is essentially nuisance behavior that wasted a lot of law enforcement time because it appears he came under the influence of something, went out in the pond, and law enforcement had to deal with him when he was kind of just shouting like gibberish noises and flailing about. It took actually quite a few officers' time, and that's really the main cost of it. Thank you.
All right, Mr. Flailing.
Thank you, Your Honor. I concur with the remarks of the state. Again, I will note the credit on the record that Mr. Connors was brought into custody on the traffic matter here, March 31st of this year, and has been in continuous custody since. So by my math, you would have 17 days. As the state remarked, Your Honor, I think that this is an appropriate agreement. Mr. Connors has been in custody, so he's received some upfront punishment for both of these offenses. He will have the burden of the additional fines and fees to pay off of, which will hopefully prevent this behavior from reoccurring, I should say, in the future. Overall, I think that this is an appropriate agreement. I would ask the court to follow it. Thank you.
Okay, Mr. Connors, anything that you want to say or add right now?
Well, I was just hoping I would be able to get out of here within 30 days so I could start. I do work.
And why don't you pay your bills?
I did not know I had 16 or 13. Was it
$1,000, yeah.
I did not know it was coming back here. I thought it was out taking care of taxes, and I was trying to contact them and figure that out. I didn't know if it was something that I was trying to get a hold through my tribe and see if I could get the help through them and their attorney. I'd actually called and left messages up there, but I did not know that the 13,000 was gonna come back to you guys. And then all of a sudden, I didn't do nothing about it. I just got a piece of paper in the mail saying there's a warrant out for me and I owed 13,000. When I thought it was all going through the state, and I was trying to take care of it through the tax raise. It all backfired, and here I am.
Okay. Well, here's the deal though. You've had other fines and fees outstanding of that 13,000 though that you haven't made payments on because you've been here, I don't know how many times in the last year or two that they haven't yet went to state debt, but we haven't gotten payments. So if you're working, then you should have money coming in, and I get you're self-employed, but you need to then come in and pay the money yourself, like come in and pay the money to the clerk. But you didn't do that.
There actually was no fines or nothing. There was nothing.
Well, there is.
3 months ago, there was nothing. There was no payments because everything was clear. They had put everything over to taxes. Everything went over there. Then all of a sudden they sent half of it back.
Did you file taxes?
I did not file yet. That's what I was trying to contact my tribe to see what to do with,
Okay.
I had some other questions.
Anyway, I'm hearing like with this case, they're not very serious. It doesn't sound like you're going to be able to get your license anytime soon. You need to stop driving. You need to stop driving because I'm going to tell you, it's not fun to have you come in for you or for me every 6 months.
It's hard being self-employed and not driving too.
I get that and I understand
I had
that.
it all taken care of and I got
Then you need to get your license or figure that out, but it doesn't sound like you can get it anytime soon because you continue to drive. So, with regards to this matter, I don't know why fines and fees and costs, because you're never going to pay them. So, we're going to, it makes no sense to order the full amount for anything. $200 DNA surcharge for the disorderly conduct, 17 days of jail with time, that is time served. With regards to the 26 CT16, you weren't asking for probation, correct? You just want him to get an AODA?
That was the terms of the offer I received from the state.
All right, you need to get an AODA assessment, but
I have to do it anyways.
you do have to do it anyway. With the operating while revoked, that has a maximum possible penalty of 1 year. I'm putting you on probation for a year. Because I'm ordering the AODA assessment. I don't have pull if you're on, unless you're on probation. Because I can't bring you in and yell at you for not doing your AODA assessment if you're not on probation. I just have to trust that you're going to do it. So far, I don't have faith that you're going to do it.
Is that if I go on under probation, is there a chance that I can get out here so I can make the money to make the payment then?
Yeah, after 30 days.
After
So,
30?
you're on probation. You have to get your AODA assessment and follow through. Work towards getting your driver's license or figure out what you need to do to get your driver's license. I am going to order 3 months imposed but stayed jail for that. So if you don't do what you need to do, then you could sit 3 months. And the 17 days that you sat is consecutive to the fail to pay fines and fees 30 days. And again, so you can understand, you are in custody
Consecutive or
for
concurrent?
what?
Consecutive or concurrent? So is it 30 days from now?
Consecutive. So
From
it
now?
starts from now. So if you're able to pay $500, then you pay they're separate things.
I
So
can't
if
pay
you're
one.
able to pay $500, you can get out of custody and the 30 days will just stay over there. But every day you can't pay the $500 is 1 day credit towards the 30 days. So if you sit 10 days and you're able to come up with $500, that 30 days gets dropped to 20 days. But then you have to make your $500 a month payments. Okay? Our clerk, Amy, is going to do an order so you know and you can understand, and I'll sign it to make sure that it has everything. So you're clear, the jail is clear, everybody's clear, and we know what's going to happen in the future. You know, I know, it'll have the full amount that you owe, everything, and it accrues interest. So you know. No, nope, we're adjourned. 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. DNA, you have the right to request it be expunged through the system through a written letter to the Department of Justice. If you fail to pay your fines and fees associated with these cases, not only will a civil judgment be entered against you, but a warrant will be issued and you could sit up to 6 months in jail for this alone, not the other stuff you owe, because it's for each. So 6 months in jail. So you must pay these off. These are included in your $500 a month payments, okay? Because it doesn't make sense to make you pay for each of the ones. So it's all together. These are thrown into the lump sum that you owe. And that's what it is. All right. 15 days of jail credit if he's revoked off of the other matter. No, it's consecutive. Never mind. So everything's consecutive.
Okay. So on the disorderly is the straight jail, and on the OAR is the probation?
Correct.
Okay, just wanted to make sure I got that. And it's 200 DNA on both.
Correct.
Okay.
Yes. All right. Thank you. We're adjourned.
Mr. Patterson, I think you may have very recently been appointed to represent Mr. Stokely.
Okay, I had not been notified of that yet, Judge.
Judge, Mr. Pat, I'm looking at the file. I was told that it may have even been earlier today or late yesterday. Okay, this is State of Kansas versus Julius Randall Stokely, case number 25 TR 2707. Counsel, state their appearances, please.
Jerry here on behalf of the state.
Your Honor, Darren Patterson, appointed attorney for Julius Randall Stokely, who appears personally via Zoom audiovisual from the Butler County Jail.
As I was, before I captioned the case, it's my understanding a judge has ordered the Mr. Patterson to be appointed. However, that may be still pending in that judge's queue. Based upon what, I'm sure that's accurate that it was approved. I looked at the application for court appointed counsel and he would qualify. Counsel, how do you wish to proceed? Do you want a breakout, or should we set this for a different time and give you an opportunity to meet with him?
Judge, if you wanted to give me a few minutes in a breakout room, I'll see what Mr. Stokely wants to do.
All right. And Mr. Ricke, I don't know if you're in a position where you could forward any information on to Mr. Patterson electronically. That would be helpful, but that may already have occurred. I don't know. But I'll approve the breakout and I'll remain available. All right, we're back on the record now with the prior appearances, as already stated. Mr. Patterson, how do you wish to proceed at this time?
Judge, as the court knows, this is a DUI case. Without a drug and alcohol evaluation, we really can't get to any type of conclusion in the case. So I'm not sure doing a plea bargain at this point would be productive, especially since I haven't seen the reports or anything about the case. So at this point, Judge, we are asking the court to continue it to a new court date, but we're also asking the court to consider issuing a new bond in this case. We would ask the court to consider a $3,000 cash or surety bond with a GPS requirement so that he would have that on. He would also agree that he would remain in Butler County, live in El Dorado while this case is proceeding. And he is in college, so he's coming to the end of the semester and is worried about not finishing if he can't be bonded out in order to take care of his college courses. So we would ask court to consider a new bond in this case.
Well, first things first, I will set this over, how far out would be productive, you think?
It depends on what the court does with the bond, because if the court does not give a new bond, then we'd want it December 1st. If the court gives a new bond, then it can be on any Monday morning and we can take care of it.
Okay. I'm looking to see what the current
May
bond
1st. I'm
is.
sorry, May 1st. I keep saying December 1st. I don't know why, but
Okay.
May 1st.
Jesus Christ.
All right. Counsel, I'm not,
Your Honor, may I say one thing, please?
hold on. Counsel, I'm looking to see what the bond is.
It was $1,500. That one was forfeited. I'm not sure there is a new bond at this point. Maybe Mr. Ricke would know.
Okay. Mr. Ricke?
Your Honor, the state, in response to the court's apparent inquiry, it would appear that there was a failure to appear back in December of 2025 after the defendant failed to appear pursuant to the terms of the 1,500 professional surety bond, and that was forfeited by the Chief Judge Ricke.
All right. I will set this on, I'll keep this on the expedited docket. I'm going to set it for May 1st at 1:30. And a couple of things concern me in regards to bond. One is that there's Mr. Stokely failed to appear in December. Bond was forfeited. And additionally, when I look at the defendant's application for counsel, he lists no income, no bills, no, zeros on everything. So how somebody manages to do that and be a college student, I'm scratching my head about. I'm going to set a bond at $5,000 cash or surety. I'm going to order that he remain in the state of Kansas and remain in contact with with counsel. At this time, I'm not going to require a tracking device. Mr. Stokely, please understand, if you make bond and then fail to appear, this judge anyway is probably not likely to put another bond on that's going to be very that most people would be able to make. I can't speak.
May I say one thing?
If you wish, but sometimes that's counterproductive. So,
Okay, I just want to say the reason why, and I'm not trying to make no excuses, but the reason why I missed court in December is because when I called the courthouse, I was in Chicago for my nephew's funeral. He got killed in downtown Chicago, so I had to go back to Chicago for his funeral. I don't know if you've seen the news story in November about 11 kids getting shot downtown and one getting killed. That one was my nephew. And when I called the courthouse, I was actually trying to figure out if I could do it by Zoom or if I actually needed to come in person. When I contacted them, they told me that there was nothing in the system regarding me at all. And that is initially why I missed that court date.
Mr. Stokely, my condolences on your loss, but you knew you had court and you had a bond. I don't know who you spoke with. I get told all the time is somebody called and they talked to somebody who told them they didn't have to show up. You didn't appear. You didn't follow through with anything that I can see. So I'm not modifying my order. But if you make bond, you need to be sure you follow through with any and all court dates. I'm going to require your appearance. If you make bond, you are to appear at the courthouse through court security. If you don't make bond, then we'll do it from where you're at today. But with the failure to appear and then a 4-month absence, that's going to be my ruling. So,
Yes, Your Honor.
very well. Anything further today?
Judge, the only thing I would ask is maybe the deputy could write down my office phone number so that if he does bond out, he could contact my office, give us his contact information. And my phone number is 316-3. Thank you. Nothing further.
This matter is adjourned and the parties are free to go. Jen, did you have anything else for me?
No, Your Honor, I do not.
Okay, have a nice day.
You too, Judge. Thank you.
That dumb automated, hard-coded, crappy closed caption thing. I tried to mute and it does no good. Anyway, hi guys. How you doing? It's been one of those nights, huh? Been one of those days for a lot of people in court. And we've just seen a little piece of what I put together. And I have a lot more. And you'll be seeing some of what I found in just about 13 hours. And we'll be doing a little brunch get together on Saturday live. Same Wolf time, well, same Wolf channel. 11 a.m. Not same Wolf time. Same Wolf time for every Saturday, right? Same Wolf time for every Saturday. Guys, I hope I see you there. We will also have an 8 p.m. premiere Saturday and Sunday, as is our new little thing that we do. So guys, come on by, hang out, watch some court, talk about it, chat stuff. What we do around here, you know? I want to spend a special shout out to Charlene. Thank you so very much for your kind contributions. You know, it is through the contributions of viewers like you we find ourselves able to do what we do. Help mama and papa keep puppies fed. Stream boss not quite as mad as he is on most days. But for now, ladies and gentlemen, until I see you again about 13 hours from now, we're live again for the weekend review. I'm your lone wolf Uso. Ladies and gentlemen, I am out. Night, Hutch. Night, bro. Night, Patrick. Lanny. Hermiticus, Mama. Rhonda. Dan. Eileen. Kat. Steven. All you guys. Thank you for coming out and hanging out. Content con. Got it. I did a thing. Good night. Good night, Lanny again. And Kat again. Steve again. I'm doing a thing. We'll have more to say about this in just a moment. see what happens when I change to the wrong scene at the wrong time, right? That's kind of embarrassing. Lord have mercy. So tonight, in memoriam of Ferris Bueller's Day Off and their little outro skit where he's like, "Hey, go, get out of here, go. There's nothing left." There's really not. There's nothing left. But this one little thing, this one little moment of wisdom I would give you that I think we all know deep down. We've heard it 100 times. But the very last case, and a little bit of my rambling right here, just goes to prove it's better to keep your mouth shut and let people think you a fool than open it and remove all doubt. Have a great night, ladies and gentlemen. I hope I see you in the morning.